Hello everyone, this is Prachi and you are watching Legal and Light. Our today's discussion revolves around these of few words like gender equality, gender parity, gender sensitization and non-discrimination. Speaking of gender equality, it has always been there in the Constitution of India, like Article 14 and Article 15, wherein Article 14 speaks of equality before law and equal protection of law. Article 15, with respect to our today's discussion, speaks that no person shall be discriminated only on the ground of sex. Irrespective of these provisions, women in our country have faced lot of struggle from the point of getting education till entering into the professional world, and judiciary is no exception to this. Before jumping upon to the current position, we need to understand that what the history has to say about the struggle of women to enter into the legal profession or to put that first foot into the legal profession. Here we have the international scenario in which we have two landmarks. The first is the story of Gwyneth Babe, who along with three others applied to the Law Society of Britain to appear for the preliminary examination of solicitor. But her application was rejected on the ground that she is a woman and she can't appear for this examination. Gwyneth Babe challenged this in the case of Babe versus Law Society. The basic argument in this case was that the word person under the Solicitor Act includes in itself women also. But this argument was also rejected. The another case is of Myra Bradwell. It was a Myra Bradwell versus Illinois. It was a case before United States Supreme Court. This case also had the similar facts and the similar arguments were raised, but again it was also an unsuccessful legal action. Now let's jump on to the Indian scenario. It was a time frame of 19th century when women were getting access to the education and even the other necessary rights, but they were far away from the professional world. There was not a single woman in the legal profession. It was like a male dominated area in those days. But three women came forward. They challenged this. They made an effort to break down the wall. And these three women were Regina Guha, Subhanshuwala Hazra and Cornelia Sorabji. The first case is of Regina Guha, a daughter of a well-established lawyer. After completing her bachelor's degree of law, went to enroll herself as a pleader. This was the first time a woman was approaching to be enrolled as a pleader. But her application was forwarded to Calcutta High Court. The case was heard by a 5-judges bench. The basic argument in this case was based upon two important statutes, that is Legal Practitioners Act 1879 and General Clauses Act. The provision under Legal Practitioner Act says that a person who wants to be a pleader shall have the necessary qualification and shall be enrolled as a pleader, while the provision under General Clauses Act says that the words representing masculine gender shall include in itself women also. Based on these two statutes, it was argued that the word person under the Legal Practitioner Act also includes women. But this argument was rejected and court unanimously held that only men are entitled to appear as a pleader. Regina Guha's case is also called as first person's case. Why? Because the whole discussion in this case, as we saw, revolves around the word person. Now the second case is of Subhanshubala Hazra. It is also known as the second person's case. Subhanshubala Hazra struggled from the step of appearing for the preliminary examination. She was restrained from entering into the exam hall And ultimately, after completing the examination, after passing the examination, when she went to enroll herself as a pleader, again her application was also forwarded to the Patna High Court, wherein the similar arguments were raised, but the Patna High Court upheld the decision in Regina Guha's case and denied to interpret the word person to include in it woman. During the time frame of these two cases, two important developments were happened. First one was the Sex Disqualification Removal Act passed in England in 1990. This was an act which allowed the entry of the woman in the legal profession. The second one was a decision of Allahabad High Court which allowed Cornelia Sorabji to enroll as a vakil. Due to the Allahabad High Court's decision, the previous decision of Patna High Court was heavily criticized. Campaigns were led so as to amend the Legal Practitioners Act, and ultimately we got our Legal Practitioner Act of 1923. The provision under this act was that a woman shall not, only on the ground of her gender, be discriminated or be disqualified from getting enrollment as a pleader or practicing law. After this decision, we got our first female lawyer, who was Cornelia Sorabji. Now let's see the first evers. The first female lawyer, as we saw, was Cornelia Sorabji. Then Justice Anna Chandi was the first female judge of High Court, that is of Kerala High Court. Then Leela Seth, Justice Leela Seth was the first Chief Justice of State High Court from Himachal Pradesh. And ultimately we got our first female Supreme Court judge, that is Justice Fatima Bibi. Of course, these developments were something India was craving for, but if we look at today's statistics of female representation in the judiciary, it is not at all satisfactory. Women constitute 30% of the total strength of the subordinate judiciary, while it is 11% at High Court level. And at the Apex Court, we have just 4 female judges out of 33. Which means that since independence we have got only 11 female judges at the Supreme Court. Out of the 4 current female judges at Supreme Court, Justice Indira Banerjee was already there since 2018. The other 3 newly appointed female judges are Justice Hema Kohli, Justice Bela Trivedi and Justice B.V. Nagaratna. Speaking of Justice B.V. Nagaratna, she is first in line to become the first ever female Chief Justice of India. Of course, for that we have to wait till 2027. This was the first time the Collegium of Supreme Court had appointed 3 female judges in row. The Collegium consisted of Justice N.V. Ramana, Justice U.U. Lalit, Justice D.Y. Chandrachud, Justice A.N. Khanwilkar and Justice L. Nageshwara Rao. Now, we need to address that what are the possible causes behind the inadequate female representation in the judiciary. First of all, there is lack of female representation at a district level or as a district judge. If we look at the basic provision, Article 233 of Indian Constitution speaks that a person to be a district judge shall have minimum experience of 7 years as a lawyer or as a pleader. But Supreme Court by one of its decision interpreted the period of 7 years experience to be an experience of continuous 7 years, where many women fail to fulfill this condition because of various family reasons like marriage or motherhood. The next is the concept of leaking pipeline. Women enter into the law colleges. They start their journey as a legal professional, but in between this journey they terminate their profession because of various family and social reasons and bar themselves to reach at their destination stage. The next is the concept of reservation in judiciary. There are many states that provides reservation for women in the judiciary, but it is nowhere at the High Court or Supreme Court level. The next point I would like to make is that women enter into the profession at very late stage of their age and reduces their chances to reach at the High Court or Supreme Court level. Other than this, there are bundle of reasons for the inadequate female representation in the judiciary, like infrastructural facilities, lack of washroom facilities for women, then the crowded courtrooms and inflexible working hours, and finally the casual sexism at workplace. Speaking of casual sexism at workplace, Advocate Indra Singh in 2019 had written a letter to then Chief Justice of India, Justice Ranjan Gogoi, about the situation of women or the current position of women or the kind of treatment they face during their work hours. She also mentioned her own experience about the discriminatory treatment, about the sexual harassment and the sexual remark in the courtrooms. She mentioned few suggestions to come out of this situation and give women a good amount of representation in the courts or in the judiciary overall. Now we need to focus on the core area of our today's discussion, that is, why do we need more women judges? First of all, more women judges will reduce the chances of gender discrimination and bias. Secondly, a judge of same gender will inspire confidence among the litigant in particular type of cases. Even though these 2 points are very subjective, we need women judges for diversity in the bench, to have different lived experience so as to conclude enriched and diversified judicial reasoning, and we need more women judges to have inclusive perspective on the statutory interpretation. Again, women have contributed a lot towards the important systematic and legislative changes. Justice Geeta Mittal was a chairperson of a committee which drafted or which designed vulnerable witness project, wherein a witness will not need to go in front of accused while giving testimony so as to give it in a comfortable and confidential space. Again, Justice Leila Seth was a part of 15th Law Commission which was formed so as to amend Hindu Succession Act of 1956, and this came up with an amendment which gave daughter the right of inheritance in the ancestral property. At the end, we need to focus on the need of gender sensitization in the judiciary. One of the judge of MP High Court granted bail to the accused of sexual harassment on the condition that if he requests the victim to tie rakhi on his wrist. After this judgment, Attorney General K.K. Venugopal requested Supreme Court to appoint more female judges so as to have diversified and sensitive approach towards the cases like sexual harassment cases. To conclude today's discussion, I would like to mention 2 incidences so as to understand that how far we have come and how long we have to go to achieve the gender equality in the judiciary. The first incidence is of 1995, a case of Rupan Deol Bajaj versus KPS Gill. Rupan Deol Bajaj was an IS officer who had made sexual harassment case against the senior most police officer KPS Gill. Advocate Indra Singh was a lawyer of Rupan Deol Bajaj. When the case started, Rupan Deol Bajaj asked her lawyer, that is Indra Singh, that why my case is not heard by any woman judge at Supreme Court. To this, Indra Singh answered, because we don't have a single female judge at the Supreme Court. The second is the incidence or a recent speech of our Chief Justice of India, Justice N.V. Ramana. In his speech, he take the basis of theory or statement made by Karl Marx regarding workers. Taking the basis of this statement and applying to the women, he said, and I would like to quote, that women in the world have nothing to lose but their chains. women shall shout out in anger and demand for 50% of reservation, not as of charity but as of right. That's it for today. If you like this video, please like, share and subscribe. And if you find it to be informative, please let me know into the comment box. Bye bye.